I was just going to ask, we know that this is a defense from liability as opposed to a true immunity. Because why?
Because we view Yearsley through the principal agency concepts, in which we do think it's a privilege that's being delegated, but we really think if you look at the substance of what's being delegated, it means that the contractor acts lawfully when it obeys lawfully delegated instructions from the government. And we agree with respondents and what my friend said earlier, which is that an agency doesn't have, like a federal agency, doesn't have authority to violate a federal statute, for example. That's just not something an agency is allowed to do. So I don't think petitioner is correct to say that the first condition of Yearsley is just whether it's within Congress's constitutional power. Of course, Congress could pass a different statute, but it hasn't. It has passed a certain statute, and an agency is not free to violate it. And I don't think the agency is free to effectually violate the statute by simply contracting a private party to do it for the agency. That doesn't really make much sense. So we think where Yearsley applies, we think the first condition of Yearsley is really about lawfulness. Could the government lawfully do it? And then second, did the government lawfully delegate that privilege to the agent? And that's why we think there's really no gap between successfully showing entitlement to the Yearsley defense and having acted lawfully. We think those Venn diagrams are just circles on top of each other.
Mr. Joshi.